there. Okay, so first of all, hi everyone, and welcome to the legal masterclass of El Programa of this year. In this opportunity, the contents of the legal masterclass will be presented by Lisbeth Flores, who is co-founder and partner at PAG Law. She is leading corporate attorney with 18 plus years of experience. And also joining us from PAG Law is Mario Larrea, who is a venture capital and startup attorney at PAG Law. PAG Law, for those who don't know, is a Miami and New York-based law firm of international scope with long experience working alongside Latin founder companies. And moderating this session, we have Jose Elias Gallegos, who is CEO and attorney of Scale and Go. Scale and Go is the legal accelerator powered by Perez Bustamante Ponce that works side by side by Ecuadorian entrepreneurs that aim at raising capital and growing globally. Okay, so about this session format, things that you have to know, question and comments can happen anytime, but for those to make it happen, what you have to do is raise your virtual hand and wait for Jose Elias to give you the word, okay? So it can happen anytime, just don't interrupt whomever is talking until you are addressed. As you may figure out, this is gonna be an English first session. However, everyone of our mentors speaks Spanish, so you can make your questions in Spanish if you're more comfortable with that. Before we start with the session itself, as you know, we will be doing a brief presentation from each one of our startups so that our mentors can have a quick refresher on where they're at. So for every one of our founders, just be conscious that it has to be a 60-second intro so that we don't extend too much in this part. I will be calling each one of you by names and just feel free to start away. So first of all, I would like to give the word to Estefania Moran from Pronto.
Hi everyone, I am Estefania Moran. I am the CEO of Pronto and Endeavor Entrepreneur. I love running. I run 20 kilometers per week. I love take photos. I am a specialist in technological innovation, and I am passionate about the development of technology to improve people's work and how through this their experience improves. Pronto is a subscription management platform that allows you easily manage collections campaigns. In a single platform, you can close the cycle for each customer. Thank you.
Okay, thank you very much, Estefania. Now I would like to give the word to David Paredes from Taxo.
I will go with the icebreaker from our side.
Okay, Jacob.
No, I'm worried. Okay, so hi with everyone. I'm currently the COO and co-founder of Taxo. What we did is to help accountants and accounting studios to improve their businesses while then give their spread peace of mind to their customers. The idea is that we want to let our accountants to be more efficient in every process. Our secret sauce is that we ourselves did a business very similar than the ones we are helping our customers to build. I'm not if I'm clear with that. So our challenge in front of Taxo is helping something that we already know exactly, because we are like customers from ourselves. It's very tricky, sorry. So that's our secret sauce. So maybe our biggest challenge now in terms of in legal terms is that taking into consideration that we don't have any legal structure yet because we are just starting our business, for good or bad, I'm not sure. We want to know how or what's the best practice or the best way to establish this new company. We don't know where to do it in this in this country or this legal, ¿cómo se dice eso? Legislation, something like that. Legislation.
Sí.
Sorry, my English is awful. And maybe I have a very specific question is that, how to do it?
Okay. Dale, Jacobo, mil gracias. Thank you very much. Now I would like to give the word to Ileana Risco from Vitruvian.
Hi, I'm Ileana Del Risco. I'm passionate about the art and fashion space. In my free time, I like to create in some way, whether it be digitally or ceramics, crochet, things like that. I'm the CEO of Vitruvian. We're a software company that helps shoppers find their size when buying clothing online with virtual sizing solutions. We launched our size suggestion tool on Shopify. My co-founders and I my other co-founders, they have backgrounds in software development and textiles, and they're really passionate about this intersection of fashion and technology. The challenge we have right now is to expand our reach for clothing stores in Latin America and around the globe through other e-commerce platforms like Tienda Nube, Magento, BigCommerce, things like that. Thank you.
Amazing. Thank you very much, Ileana. Now I will give the word to Martin Romero from Sabroso.
Hi, I'm Martin Romero. I'm the CEO of Sabroso. I'm actually going to be a father soon, but something funny is I've never changed a diaper. At Sabroso, we make it easy for companies to order daily meals. Employees can order, cancel, and review their own orders. We're eliminating the Excels that typically companies receive in order for them to place employee meals. One of the biggest challenges we have is forming the correct structure to please our investors. For example, in Mexico, they hate to invest into Cayman structures versus in the US, they like to. So how do we balance that out?
Super, thank you very much, hands-on. Now, last but not least, I want to give the word to Augusto Fernandez from Mox.
Thank you, Leonardo. Well, I am Augusto Fernandez. I'm a big fan of football, and I love.
Just muted yourself.
No. I'm a big fan of football, and I love playing the guitar. I'm also the CEO of Mox. At Mox, we are transforming the fintech landscape by developing the underlying infrastructure that connects financial institutions and fintechs to consumers and their paychecks. Basically, what we're doing is through an API-first architecture, we're unifying the communication channels of payroll data and making this easier way to communicate payroll data between different institutions, but also between different applications. And in terms of our biggest, I guess, legal challenge for this meeting is that, and something that we touched with Fernando and Leo last week, is that we're considering expanding to Ecuador, and is what's the most cost efficient but legal way of doing this, right?
Oh, okay, amazing. Thank you very much, Augusto. It's been very clear from all ends. Thank you very much for giving us a brief overview on the startup. And now we're gonna get our hands dirty. So for now, I'm gonna give the word to Jose Elias. Jose Elias, the space is yours.
Thank you, Leo, and happy to see you all. Happy to be here as always. We've been discussing with Liz a bit about the format of the presentation. She has prepared for us a presentation with sort of 10 pinpoints, right? 10 10 pitfalls to have a look at them. And if possible, we will like at the end of each one to sort of open an interactive conversation. So please, Liz, the floor is yours right now.
Okay, everyone. Well, it's an honor and a pleasure to be here today. Much appreciate the invitation from Wentrip. As was mentioned, my name is Lisbeth Flores. I'm a co-founder and partner at PAG Law. We have offices in Miami and New York. I'm in Miami because the weather's better than in New York. We practice Florida, New York, California, and Delaware corporate law. Pueden hacer las preguntas en español. My background is a Mexican family, grew up in California, so Spanish is totally fine. And I appreciate you bearing with the presentation in English because it is easier for me, pero entiendo todo. So I'm gonna go ahead and put my presentation on the screen. Let's see. For some reason, it's not coming. Let's see. It's
Yeah, now
oh, there it is. There it is. Okay, I got it. Okay. All right. Can everyone see that?
Yep.
Okay, great. So these are the top 10 pitfalls for LATAM startups. And by pitfalls, I mean things that will make it difficult for you to raise funds and perhaps have a successful exit in the future. When I've run this presentation by venture capital funds, they say, yes, please tell founders to heed these warnings because these are things that we see all the time and they make it difficult for us to fund companies and oftentimes can prevent us from funding a company. In the worst case, a company can become unfundable. Not to scare you, but we're here to help so that doesn't happen. I have a disclaimer because I'm a lawyer and I love disclaimers. It's not legal advice. It's just a summary of some basic principles. First of all, it is very important to be aware of legal concepts from the beginning of your journey. A lot of startup founders, they wait until later, wait until there's more money because they believe that lawyers are expensive. And unfortunately, oftentimes there are some ways to save that we can go over on legal fees. But the problem is if you try to do things yourself from the start without the help of a good lawyer who understands startups, then it can be very costly to clean up later. I liken it to a house. Your legal structure is the house where your company lives. And so I'm a lawyer, I'm not an architect. I would never try to design or build my own house. If I did, it would fall on my head. You're all brilliant founders. I've heard all about what you're doing with your companies and it's incredible, but we try to stick to our knitting and hire a good builder to build your house, hire a good lawyer to help you from the beginning. I always say we make a little bit of money forming companies, forming holding companies, getting the documents in order from the beginning. We make a lot of money when our clients have tried to do it themselves and we have to clean up the mess. That is very costly. So the choice is yours. So first pitfall is failing to protect your IP. Your company should have a right to use all of the IP. Oftentimes the IP has been developed by the founders before the company was formed. That's fine, but the IP should be duly transferred to the company prior to doing anything. That should be a first priority. There is a document called a confidentiality and invention assignment agreement. Most investors require this, but don't wait until you have investors. Get these signed from the very beginning, because if an investor sees that there was, for example, an employee or a founder who left before the round and didn't sign a CIAA, sometimes it's hard to get them to sign when it's time to do the round. They might not want to cooperate for whatever reason, and this creates a potential risk that they might claim some rights to your IP, or they might not have pledged to maintain company information confidential. So the rule is everyone who touches the IP needs to sign a CIAA. That's founders, key consultants, key employees, key advisors who might be developing your intellectual property. The good news is these are a standard form, and they're very inexpensive to, a lawyer can provide you with a form, for a few $100s at the most. It's very basic. And again, this is an area where a few $100s of investment, if that, can save you your company in a worst case scenario. And also register your trademark early. We've seen companies move forward without registering their trademark. Then they find out that the trademark is disputed and they have to change the brand. And that is very costly, and could have been prevented by investing a few $1,000s early on in registering the trademark. At this point, are there any questions there on Pitfall 1? And you can raise your virtual hand and we will call on you.
I have a couple of comments, if I may, just to add on it. I will add that it's super important to never forget your local counsel also, depending on where you're developing your solution, because you should also take into account local intellectual property laws depending on your structure. And also that applies with your trademark registration. If you register your trademark in the US, for example, that doesn't mean that you own that right under all Latin America. And as a friend of mine sometimes told me, that startups have multinational company problems, but like being this small. So yes, you have to take into account your trademark registration strategy throughout your expansion planning. Because what I've also seen is that you may be forced to change your trademark if you're willing to enter to Colombia or Chile or Argentina and such.
Excellent advice. Okay, if there's no other questions, we'll move on to pitfall number 2. Pitfall number 2 is not talking to a US certified public accountant. And by the way, this is valid even if you don't have a US holding company, even if you have a Cayman company. Why? Because your investors oftentimes will be concerned with US tax implications. And just to get the advice of a CPA in the United States is not terribly expensive. They charge less than tax lawyers. That's why we generally recommend using a CPA for tax advice in the US, not a tax lawyer. They usually charge a third or a half of what tax lawyers, and they make the filings for you. Tax lawyer does not make the tax filings. So usually you can talk to a good CPA. If you have a good lawyer in the United States, they can recommend one that knows what they're doing. It can cost tens of thousands by not making necessary tax filings or forming the wrong type of entity. We have many clients who formed a C Corp because that's what everyone said was the thing to do without consulting a CPA. Unfortunately, they found they were paying a lot of money in taxes to the United States, maybe without even having operations in the United States. That could have been avoided if they spoke with a CPA or even an attorney who would have told them what the case was. We had a couple of years ago a case of a unicorn. They had raised hundreds of millions of dollars, and yet they didn't want to spend a few $1,000s hiring a US CPA, which led them not to make certain elections that they had to make in the United States. It didn't destroy the round or make the company unfundable, but it cost a few $1,000s more in lawyer fees to resolve the issue. So better just to talk to a CPA from the very beginning.
I have a question for you, Liz, maybe. Like in here, like in this cohort, we have some pure Latin startups, right? With their operating subsidiaries, but we have also one American-based startup. Is there any difference in organizing your structure on both sides? What can you recommend us a bit about it?
Yes, and certainly every case is different, right? So every company should talk to a CPA about their particular case. Generally speaking, if there are significant operations based in the United States, then a C Corp might make more sense because the company will have to pay taxes in the United States anyway. So there, the C Corp becomes less of an issue. For companies that are based mostly in Latin America and their operations and profits come from Latin America, oftentimes a C Corp it'll subject them to US taxes, and that's unnecessary. They could just as easily these days raise funds through a Cayman company. Again, important to, before forming the holding company, important to discuss with a good tax accountant. Any other questions on this point? Okay, no sean tímidos. Moving on. Pitfall number 3, forming a foreign holding company before talking to a lead investor. Another mistake that we found made is, companies understandably want to be ready to get an investment from an international investor. And these, before it used to be the C Corp, maybe 3 or 4 years ago. Now we're seeing actually the majority of our clients operating in Latin America opting for Cayman holding companies because of the tax benefits. Many of our clients, they haven't yet lined up a lead investor for their round, but they are assuming that the lead investor wants to form a Cayman company, or in the past, more often a C Corp, and they are in a hurry to form it. And we tell them, you don't have to do it now. We can do it if you want. It does have the advantage of making you ready so that you don't have to take that extra step of forming the holding company before you close the round. You can close the round a little bit more quickly. If you form a C Corp, for example, and a company, an investor comes along and says, no, we don't invest in C Corps, we only invest in Cayman, or vice versa, then it can cost you an investor. I would suggest getting a little guidance from your potential lead investor as to their preference before actually making this decision. Because forming a C Corp, it's very difficult to get out of a C Corp. There are big potential tax impacts if you form a C Corp and then try to go to a Cayman or an LLC or another structure. A Cayman company is somewhat more expensive to form. You add maybe $5,000 to your formation costs and a couple $1,000s more minimum in annual fees, and that's a lot of cost for something you might not need yet. And it's like buying your wedding dress when you don't even have a fiance yet. But maybe better just wait until you know it's going to happen, and then make your decision accordingly. Now, one good middle ground is forming an LLC holding company. Because the nice thing about an LLC is you can do the flip from the local company into a Delaware LLC, and then later put it under a US C Corp or a Cayman company. So it's very flexible, and it's not very costly to do. If you're raising on safes, you really don't have to form a foreign holding company. The Y Combinator SAFE, by its terms, already states that if you form a foreign holding company, that SAFE will automatically transfer to the holding company. You don't have to get the signature of investors. You don't have to do anything. When you raise through Delaware or a Cayman company, the SAFE automatically is transferred to that company. So it's very well thought out. It's very convenient. No reason to form the foreign holding company if funds are tight and you don't really know who your lead investor will be. Yes.
I have a question for you, Liz. Like, talking money-wise, right? When would be advisable to think about a Cayman structure? Like, what are you seeing? What are you seeing, like, money-wise or round-wise? And like when it will justify like just to take that leap?
Mm-hmm. I would do it really once you have a lead investor lined up. If you've been talking to a fund, they prefer Cayman, they will most likely be a significant investor for your company. Then I would say Cayman these days is a pretty safe bet. But again, it is a cost. It is a few $1,000s in cost to do the flip and to maintain the company. So I would make sure that it's really what you want to do. And of course, again, talk to a tax advisor. The beauty of Cayman is you won't get taxed in Cayman unless there are operations in Cayman, which is usually not the case. A few things to consider, a few downfalls of Cayman is if you plan to have a lot of US investors, it might be a problem. If you have over 50% US investors, Cayman can be a problem under the US tax laws. There's an issue called CFC, which creates some bad tax implications for foreign companies where there are more than 50% US investors. So it's not a perfect solution. It's not appropriate in 100% of cases. Again, get good advice based on your particular situation. And Jacobo. Oh, you're on mute.
Disculpa, ahora sí. ¿Me escuchas bien?
Sí, ahora sí.
Sí, ahora sí te voy a hablar en español mejor porque ahí no me trabo.
Sin problema.
Muchas gracias por tu presentación. Mira, en tecnología nosotros hablamos mucho de los best practices, ¿no? Y de los estándares. Nos encantan los best practices porque nos parece que es lo mejor. Y en el mundo legal es difícil pedirle a un abogado que nos dé cuál es el best practice porque como que hay demasiadas variables y es un relajo. Pero quizás invitándote un poco a nuestro mundo de tecnología, me atrevería a pensar que el best practice es cuando estás arrancando, me refiero, ¿no? Si estás desde cero, ¿no es cierto? From the ground, si no tienes absolutamente nada constituido, me da la sensación que el best practice podría ser constituir un LLC en Delaware, ¿no es cierto? Y después, esta estructura te da un poco la flexibilidad de migrar hacia una estructura en Caimán o volverte una C Corp, dependiendo de cómo se van dando las cosas. Corrígeme si estoy en lo correcto, porque, lo que quisiéramos nosotros es, lo más rápido posible, hemos venido aguantando la constitución de nuestra empresa justo para esta reunión y tener un poco de claridad. Solamente quisieras tener tu opinión de si consideras que eso puede considerarse un best practice o no, nada más eso.
Yo lo consideraría como un good practice en muchos casos, que es la respuesta que siempre abogados dan, ¿no? ¿Por qué que es un good practice? Justamente por lo que mencionaste, que es muy flexible y no te va a encerrar cualquier camino y también va a dejar más ágil la eventual flip para Cayman o para un C Corp. La flip lo llamamos el proceso legal en que ponemos un holding company encima de la compañía que ya tienes. Y si tienes operaciones en varios países, es bueno de una vez constituir una holding company para ya dejar todo colgando de la misma holding, porque luego sí es muy fácil hacer el flip para Cayman, pero entonces sí estás pagando por dos flips. El segundo flip sí va a ser más sencillo, pero es un coste adicional a tomar en cuenta dependiendo del dinero que quieras gastar. Cuando hacemos flip de compañías en Latinoamérica, vemos que muchos de los delays son locales. En varios países, las implicaciones fiscales de hacer el flip o cambiar la constitución accionaria de la empresa local pueden tardar mucho. Entonces, en esos casos sí es una buena idea hacer un flip para el LLC de una vez, dejar todo colgando y luego cuando es hora de hacer el flip para Cayman, si es el caso, eventualmente es mucho más ágil.
Buenísimo, muchas gracias.
De nada. Augusto.
Thank you, Liz. And this question goes more not for the initial formation, but maybe later on for the flip. What's your point of view? Because I've seen some startups, Latin American startups, that instead of doing the Cayman or the US C Corp, they've done the UK flip. I was wondering what's your experience with that, because also the UK has some tax incentives for investors as well as for companies that may be useful for startups. Just wondering from your experience if that it's a little more complex, or from an for example, from an LLC doing that flip to the UK, is that harder than doing it to the Cayman?
It's harder and it's more expensive. And I would say it's not very standard for Latin American startups. To give you an idea, at our firm, we've done, I would say, probably over 300 flips in the last 5 years. And I think, maybe 3 were into UK companies. It might be appropriate where your investor base is significantly European. It might, but again, you're going to have to get very, specialized UK tax advice to validate that. One trick that I would urge you to do is, look on AngelList, look on databases, and see, there you can see who invested in what companies, and you can see what type of holding company they used. A UK company is more common than some, but I think it's far below Delaware and Cayman. Most funds investing in Latin America are very comfortable with Delaware and Cayman. Again, I would talk to your lead investor if they're insisting on it, and do your homework getting the right tax advice. But generally speaking, it's not very common, and there's a reason for that. It's quite costly, and maybe of limited advantage in most cases. Fernando.
Thanks, Liz. A question that we usually get with a lot of founders is, since LLCs are so easy and cheap to set up online, they ask me, should I talk to a lawyer now, or should I just go through legalzoom.com or something and just pay $500 and have like a standard template set up? What would your recommendation be?
So, I like those. I think those sites are really good for a lot of things, and no problem forming an LLC on your own. You can save, some money, but do get a lawyer, because it's one thing to form an LLC. Another thing, every LLC must have an LLC operating agreement. This is like the pacto societario of the LLC, and that is a legal document, and it governs the relationship among the founders. That has to be looked at by a lawyer. The other thing that has to be looked at by a lawyer is, how are you going to put the existing operating company underneath the LLC? No online platform that I'm aware of can do that, because you have to take into account the particular capital structure and the local requirements as well. I think, in my experience, everywhere, Chile, Colombia, Mexico in particular, have very specific implications for doing a flip that, if done incorrectly, can create bad tax impacts. Your local attorneys in country can tell you more about that. But for the pacto societario and the flip, it would be important to consult an attorney.
And just a quick commentary on the last question. I don't know if the UK is similar to the rest of Europe, but the problem of fundraising in Europe is that, you know, new money coming in is taxable. So I'd be very careful with setting up structures in Europe.
Yeah, definitely don't opt for a more, let's say, unusual structure. Don't opt for any structure without, talking to qualified lawyers and accountants, because it can be quite costly. Martin.
Yeah, I have two questions. Actually, one is basically on the Delaware LLC. I know every year you have to send out a K-1 tax form to investors. Does that get annoying and time consuming once you have like too many investors? That's why they say, hey, go into a C Corp or go into a Cayman.
It does.
Is that something you should be aware of?
Yeah, you should be aware of it, and definitely talk to an accountant to get sort of the idea of the costs. Yes, and let me just say that an LLC is not usually acceptable for most VC funds, right? So an LLC is a good option when you have sort of more angel type investors, individuals, personas físicas. When most funds are constituted as pass-through entities, and they don't like to get K1s. That's why they usually in the past would say C Corp. Now they're more likely to say a Cayman company if the company doesn't have significant operations in the US. It depends from fund to fund. But yeah, the K1s are an annoyance to many of our clients. We've had a lot of clients that have been LLCs for a long time and actually have raised a lot of money through an LLC. And they've asked us, well, can we convert to a C Corp or a Cayman because this is annoying, the K1s. And so we do an analysis, right? We say, look, this is what's going to cost you to do the flip. These are the annual maintenance fees. These are the potential taxes if you go into a C Corp, and you weigh the costs and benefits. Every structure has its particular annoyances. You just have to determine which one is more appropriate given your particular case.
Yeah.
Just a
And
quick.
then the last one, I
sorry.
heard a lot. Oh, dale, Fernando.
No, because it's relevant to your first question. But as far as I understand, if an LLC is just a holding company, like, and has had no actual business during the year, there's no need for a K1. So it's usually at setup, and then when something else happens, our funds are LLCs, and we only send out K1s at the beginning when we receive the money, and if there's no movement, no exits or anything, there's no K1s. There's no need.
But Fernando, what happens if you, for example, use that LLC to open a Stripe account and start charging,
In that case, it's an operating company, then you have to.
Okay.
Then it's different. But if there's no money coming in or out of the company, then there's no need for a K1.
Oftentimes, and again, talk to your accountant, every case is different, but oftentimes what companies do, if they have an LLC as a holding, but they have some sort of operation in the United States, they will also establish a C Corp to isolate the US operations, and the C Corp will pay any taxes. You want to be very careful about putting operations into your holding company, wherever the holding company is. In the first case, funds don't like it. They don't want to see, in most cases, operations in the holding company. They want it to be a pure holding company and the operations underneath. And if it's an LLC and you have any US source income, then you could be taxed on the global income of the company. So it will not only, the US will try to not only tax your US source income, they will try to tax your income in Ecuador, in Chile, wherever you operate. So be very careful, talk to a professional before putting any operations in the US.
And then the other question I had is, in our countries, paraísos fiscales are looked really badly. And let's say Cayman Island, if you have a lead investor from Mexico, they won't even invest there because they can't because of the relationship. I heard a lot about Canada and Singapore. What do you think about those places?
We do see those from time to time. Again, similar to the UK, they are more expensive even than Cayman in my experience. You know, the expensive advice, expensive to form. And I would say they still are not standard. You know, there are various things that we've seen. For example, yes, Mexican investors do. Sometimes there's a blocker company. You know, a lot of you know, Latin jurisdictions also from time to time have had issues having a Cayman company as a shareholder. That's why we have a Cayman LLC sandwich. So in general, whenever you have a Cayman company, you should have an LLC under it, which is the direct shareholder of your local companies, because some countries, Argentina, for example, has issues with having Cayman shareholders. So the LLC is like a blocker against that. We've seen Mexican investors getting more comfortable with Cayman, either because they put a blocker company or they invest through you know, some sort of offshore entity that they might have. But yes, I mean, certainly Canada and Singapore are other options. They're just not terribly standard at this point. So I would definitely make sure that is the best option before proceeding.
Okay, thank you.
Okay. Moving on. So pitfall number 4, not making your shares subject to vesting. Now, of course, when you get a lead investor, they are going to require that the founder's shares be subject to vesting. Why? Because they want to make sure you stick around. So a lot of founders have the idea that, you know, vesting is something they've got to do once they have an institutional investor, but no reason to do it before that point. But the problem is, and I've seen this several times, is sometimes you know, you have your group of founders, your best friends, you're getting along great, everything's wonderful. Each one has a certain portion of the company. You know, in one case where there were 4 founders, they split the company 25% each. And then one of them decided he got bored and wanted to turn to other projects, and his shares were not subject to vesting. So at that point, he had 25% of the company for basically doing nothing while everyone else was working really hard for the success of the company. So the vesting is not only a protection for your investors, it's a protection of each founder, because things happen in life, right? The person might, you know, they might change their priorities in life. They might get a better offer somewhere else. They might decide the startup lifestyle isn't for them. So, you know, if their shares are subject to vesting, perfect, they can go on their merry way, and then you take back the portion of shares that's unvested, and you don't have to explain to future investors why there is you know, a guy that doesn't do anything that has such a big or a guy or a girl that has such a big percentage of your company and has basically disappeared. So any questions at that point?
Yeah, can you tell us a bit about the basic structure, like cliff time, like what's industry acceptable and what could be weird at least?
Yes. So the standard now is 4-year vesting with a 1-year cliff. That means 25% of the shares vest after the first year, and then the remaining are sort of trickled out month by month after that time. And how does vesting work? You issue the share for founders. Usually you issue the shares, but a certain amount of them are subject to derecho de recompra, the ones that are unvested. So let's say, you know, I found a company with Mario, and you know, we each have 50% of the company, and you know, I leave before any of my shares are vested. The company can now repurchase my unvested shares for a penny. So, you know, very nominal price, and you know, I go on my way and I don't have any shares of the company. Okay, and I don't know how we're doing on time, guys. I know we don't have a lot of time left, but
we still have 15 officially allotted minutes, so I think that you can go through the presentation and we can continue
Okay, maybe I'll go through the next 5 pitfalls, and then we can save any remaining questions towards the end.
Amazing.
So we've gotten a lot of questions, and that's great, but want to make sure we cover everything. And of course, Mario and I are always available, for anyone that wants to discuss. So number 5 is not understanding your cap table. It's amazing. Our founders are so good with math, so good with spreadsheets, but for many founders, they see a cap table and it's like, I don't want to think about it. You lawyers just take care of it. That's a big no-no. Of course, the lawyers were happy to take care of it. But if you understand the cap table and understand the impact of the securities that you've offered, such as safes and convertible notes on your cap table, that's who owns your company. That is what you own. That's what you've been working for. So you need to understand it. Ask your lawyer to explain it to you. If you understand the cap table, you can save significant lawyers' fees. Working with cap tables is very time consuming. And therefore, if you leave it to the lawyers to do, it can really run up the fees. It's not because we're trying to take advantage. It's really because it takes us a lot of time. And it'll make you a better negotiator with your investors. Believe me, the funds understand cap tables perfectly. So you want to negotiate with the same knowledge as the funds. So make sure you educate yourself about the cap table. That said, the cap table is just a picture. It's a photograph of who owns your company. It is not a document with legal effect. So, just because it's on a cap table, if the cap table is wrong, the cap table has no effect. It is the signed legal documents that state who owns your company, and the cap table should be a summary in a spreadsheet form or on Carta, which is a great online platform, and there are others of what the legal documents say. But if someone is disputing the percentages that you've calculated, it's the legal documents that govern. Pitfall number 6 is not communicating with angel investors. We always tell our clients, there's a certain point when you have a term sheet signed, you should talk to your angel investors and let them know what's coming. The worst thing, and we have, a round that was delayed by, at least a month because the client chose not to talk to the angel investors until the round was supposedly going to close. But the angel investors had other ideas and they tried to negotiate the documents, and it took a month of back and forth to get the angel investors comfortable with what was going on in the round. So make sure you talk to your angel investors. They've been so kind as to fund your company from the beginning. Good communication, as in every relationship, is key. Pitfall number 7, issuing equity too early. If you issue a preferred equity or have a very complicated shareholders agreement governing your local company, then the flip can be lengthy and costly. I love safes. I think they're great for founders. Think about doing a safe, or if your investors don't accept a safe, a convertible note. The more equity you have, the more issued early on, the more complicated it can be to eventually do a restructuring if you need to before the round. So I would wait. If you haven't done your flip yet, I would wait until you actually have a flip imminent in a round. Number 8, this is a huge cost when it's not done properly, and it's so easy to do. It's a very small initial investment that you can make to save yourself a lot of cost and headache and possibly legal issues down the line. Keep a good file. Make sure every time you have legal documents signed, you know where they are. You can pull them out quickly. You know where all your files are. The documents are completely signed. Yes, your lawyer will take care of that. But let's say if you want to change lawyers later on, or you change jurisdictions, or you have a VC fund that wants to do diligence. If you have a nice orderly file, you can immediately, within a few hours, put together a data room that any investor will feel comfortable looking at. If your files are a mess, then it's going to be time consuming and probably costly to fill in the blanks later when you forget what was signed and you have to look through your emails and recreate the wheel. Make sure every time you do any sort of legal operations, you get the complete signed documents and PDF form, of course, and put them in a secure file where you can easily access them later and they're well organized. Pitfall 9, hiring a finder. A lot of our clients ask us about this. Hey, I have this guy and he knows a lot of investors. And if we give him a share of the round, he's going to find us, millions of dollars of investments. Beware. If the finder is not registered with the SEC, that's the securities regulator in the United States, they could subject you to very heavy fines or cost you reputationally. All the funds that I've talked to don't look kindly on founders. They want to be approached directly. Finders, they look kindly on founders, not finders. They want the founders to approach them directly. They don't want to be approached by a finder. If they're approached by a finder, they assume the founders don't know what they're doing, and it can be a waste of money and maybe even damage your reputation. Never give transaction-based compensation to anyone who helps you find investors. Never give any sort of compensation which is based on the success of the investments that they find. And if you have questions as to what that is, that's a lawyer will tell you. But I would just try to steer clear of these people. If they're charging you a fee to find investors, they probably are. Most of the time, I haven't found those people to be too successful. So be careful. Then finally, pitfall 10, being too innovative and creative. I know you all have innovation, smarts, and creativity. These make you successful founders. But as we were discussing before our time started here, we've seen companies, try to innovate on the legal documents, right, without consulting a lawyer, try to modify a safe, change around the language in the Y Combinator safe, devise their own very creative conversion formula for a convertible note. Very smart, guys and gals that try to do it. This can make a company unfundable. And in the worst case scenario, a company that was otherwise very successful has basically had to shut its operations because it tried to modify the safe. In another case, closing was delayed by about a month while everyone tried to figure out the conversion provisions of the convertible notes that the company had invented on their own. So there are standard documents, and don't get a lawyer who tries to show you how smart they are by inventing their own documents. All the documents should closely conform to NVCA standard documents, Series C.org standard documents, or Y Combinator standard documents. If you can't find the document that you're using to raise funds online, generally speaking, don't go near it. In the venture capital world, it should be something very standard. You don't have to wait and explain to an investor, what this document is. They don't want to spend time and legal fees reading your very customized documents. They want to see standard Y Combinator safes, NVCA standard documents. So that's all I have. And I think we have a little bit of time for questions.
Yes, we do. So everyone, please shoot.
Oh, Ileana.
Hi, yeah, so I have a question regarding, we're based in the US, but hiring in Latin America, like any guidelines in, I guess, that bridging of hiring and the legal documents needed for that to make sure we're in compliance here and over there.
Yeah, and so I would echo Jose Elias's advice, local counsel, because as you all know, labor laws in Latin American countries are very strict. So you want to make sure you have local advice in the country to let you know what needs to be done. But in addition to that, on the US side, even if these folks are in Ecuador or Colombia, have them sign a US law CIIA, that Confidentiality and Inventions Assignment Agreement. That is very important. I would say that's almost one of the top 3 things that funds look for, to make sure these people have signed these agreements from the very start. And like I said, it's so cheap to do. It's such a standard form. Why would you ever not do it? That's my advice.
Perfect. Thanks so much.
Carmen.
Yeah, just zooming in on what Ileana just asked, what's your stance on platforms such as On Top, Deal, these third companies that help recruit, hire, and manage personnel abroad?
I think they're great. I can't, obviously pronounce as to any of these companies' compliance with local laws. Obviously, that's local counsel that can tell you about it. But look, there are a lot of online platforms that are great. I think the general rule with online platforms is, remember, they aren't legal counsel. And I think any good legal counsel, when an online platform is appropriate for our clients to save money, we tell them, go ahead. We're not trying to, get legal fees out of our clients when they can do something more cheaply somewhere else. I would rather have them save their money and then spend it on lawyers for things that are important and can only be done by lawyers. If you have trusted counsel in your country where you're hiring, they can definitely tell you what their view is. The way the general counsel of On Top is a former PAG lawyer. They snatched her from us, so I know she's very good. I know they have a great lawyer in house, but of course I can't say as to whether they are compliant in any particular country. Augusto.
Yeah, just to follow up on that point that Carmen just mentioned, if you were to use one of these platforms, who is the one that has the relationship with that contractor, that person? Is that the local operational company, or is that for example, the US LLC?
So that's a good question. In most cases, it is the local company because again, you don't want to usually have operations in your holding company. Also, particularly with employees and sometimes with contractors, they really need to be hired by a local entity. It just makes things a lot easier in terms of regulatory compliance, taxation, etc. It's very rare that it would be appropriate to hire people out of the holding company LLC. It's done sometimes just for convenience, but it's oftentimes not the best option.
I would add a bit on that. It's like, just remember that Latin American labor laws are super protective. So sometimes you're not solving the problem. Like you're just creating one just to save the Seguridad Social and any of the benefits, of the legal benefits. If you're having a holding company and an operating company, so there are many little details that may not solve what you're looking to solve, basically.
Yeah, you don't get out of, let's say Argentine labor requirements if you hire an Argentine out of a US LLC. The requirements of the country where the person is located are the ones that apply no matter what company needs to hire them.
So I have a question. Y Combinator doesn't offer a standard safe for LLCs. And so we've seen a couple of versions, PagLaw drafted version. I think Brian Record through Latitude has one. Do you have any recommendations there as to how we can standardize around a single safe for LLC?
Yeah, the one that we've come up with and have been using. It just simply says that, you know, for if the company is an LLC, it just adds a sentence that says the company if it is an LLC, then the corresponding equity terms will apply. Just to, again, because I don't like to mess too much with the Y Combinator safe, but you know, I think they're all fine. I mean, it's you know, as long as they don't mess with the substance. You know, there hasn't been one that's been sort of decided by the market yet, but you know, as long as the, you know, I think I'm not sure which changes Latitude has made, but you know, I would guess they're probably fine. I don't have a strong preference. And it looks like that's time, and I see Leonardo, you have your hand up.
Yeah, rather than a question, it was more a comment. I want every one of you know that you have a space for legal office hours where you can go in deep to anything that has been flying in your specific cases. So just want to know that if you haven't assigned it yet, make sure to go to the link in the Notion and do that. And on the other end, it is actually time. So first of all, I want to be very thankful for Lisbeth, for Mario, for Jose Elias, for being part of this very educating space. I mean, I think that if we extended it half an hour or another hour, we would still have a lot of talk. So I don't expect for every single question to have been addressed, but you now know what are the main pitfalls, thanks to everything that we've been discussing so far. And now you know exactly how to prepare yourself for what's going to be now the office hours. So please do that. And again, Lisbeth and everyone, Mario and Celia, thank you very much for your time. And it's been from my end, a very, very educating session.
It's been a pleasure, guys. And I just posted in the chat an article by my partner about, you know, Cayman holding companies. He's published a lot of articles that I think are relevant to the questions that we've discussed today, in case anyone wants to check it out. And you know, thanks to Leonardo and Jose Elias and One Trip for letting me speak today. You all have my email, you have Mario's contacts. We'd be happy to discuss anything.
Thank
What I'll
you.
do, Leo, I'll send you all the articles and latest information so you can, you know, share with the group. Perfect.
Amazing. Okay, so I'm gonna stop recording and thank you everyone for your time.
Thanks everyone.
Bye, gracias.
Thank
Bye,
you,
guys.
Lisbeth. Gracias, José Elías.
Gracias.
Thank you.
See you soon.